And I always like to start with a positive focus, something positive that happened this past week. And I've been talking about this, but coaching my son and daughter in soccer. Well, I guess two positive focuses. One, coaching my son and daughter in soccer. My daughter's team won again and had a great practice and really enjoying it. And my son, he's really turned a corner in terms of his effort on the soccer field. It was playing pretty physical and rough like his dad used to. So that was pretty cool. Also, I did bribe him. I told him I'd pay him $5 if he knocked down one of the other kids. Sounds harsh, but it got my kid a little more physical, a little more involved in the game. So that was kind of fun. And then the other positive focus is that I had a total hip replacement March 9th, and the recovery is going really well. And I even did a workout that involves 250 air squats. So if I can squat 250 times with a hip replacement, then I'm doing pretty good. So that's my positive focus. Hopefully something positive happened for you this past week as well. So this is always just general information. Keep that in mind. If you want to see how this applies to your specific situation, feel free to reach out to us or give us a call or just reply back to that email. And so first question. And first question is, all my assets list two beneficiaries, 50-50, and I have no will when I pass. The financial institutions have to pay out when provided a death certificate. Question form. So what the person's talking about is he has or she has an investment account, listed two beneficiaries, maybe equally to the two kids. When you pass away, you provide a death certificate to the financial institution. A lot of times we use TD Ameritrade, and then that financial institution or custodian will then direct the whatever's in the account to the two listed beneficiaries, thereby avoiding probate. Who is responsible for any taxes and debt? So if they were to inherit, say, a pre-tax account like an IRA or something like that, and it goes to a beneficiary, then the beneficiary is going to be the one who's responsible for those taxes. And again, this is something that we've talked about that's kind of changed. They used to be able to stretch it out over their lifetime. Now, if it's a pre-tax account, all the taxes have to be paid within 10 years due to the Secure Act that recently passed back in beginning prior to 2020. With regards to the debt, it really depends on what type of debt it is. There's two types of debt. There is what's called unsecured debt. This is debt that is not secured by any type of lien on any assets or property, for example, a credit card debt. Then there's secured debt. So this type of debt is secured by some type of lien that they place on the asset. The most common version of secured debt would be, say, a mortgage, right? So interesting thing is unsecured debt, when you pass away, basically passes away with you. So like credit cards, you don't have to pay mom or dad's credit card debt. Secure debt passes with it goes with whatever the asset is. So if you bought a car and you owed on the car, whoever receives that car would also be responsible for the debt. The big one is typically with regards to like real estate. So let's say the home's valued at $300,000, but we have a lien or a mortgage of say $150,000. Now, however, that home goes to the beneficiary. The mortgage company never did an agreement with that beneficiary, so now it's going to trigger a due on sale clause. And so now that beneficiary would have to satisfy that mortgage either with funds, existing funds, or from their inheritance, or they have to refinance it, or they have to sell, and instead of getting the $300,000, they'd be walking away with $150,000. So really the debt piece, it goes with any of the assets if the assets have debt. And then the follow-up question is, will probate be initiated? It really depends. A lot of times we see probate with regards to real estate. So you might have beneficiaries on your 401ks, IRAs, life insurance, checking, savings, but what about your house? Okay, that's probably just in your name or joint with a spouse. And that's where a lot of times we'll do what's called a ladybird deed, which is a type of deed to say it's in your name while you're alive, and then upon death it goes to whoever you listed as a beneficiary. Or depending on the type of trust we've done or we'll do, we'll deed it directly to the trust. So that's how we avoid probate with real estate. But really, at the end of the day, it's all about just understanding estate administration when someone passes away. And there's 4 ways that assets transfer upon death. One would be joint ownership. Second would be beneficiary designations. And this is kind of what the question is relying on. Third would be through a trust. And there's different types of trusts, and not everyone needs a trust, but a lot of times we do a trust. But if an asset doesn't pass through one of the first 3 ways, then it ends up going into probate. And that is something that we want to try to avoid because it's a core process, it's time consuming, and it's costly. And in reality, a lot of people think a will avoids probate, but it does not. What a will does is gives instructions to the probate court on how to administer your estate. So if you're looking at avoiding probate, you don't want to rely on a will. Instead, you want to rely on one of the first 3 ways, whether it's joint ownership, beneficiary designation, or trust. And a lot of times we don't want to rely on joint ownership because with joint ownership, it's great for a spouse, but we probably shouldn't be adding other people joint to any of our accounts or any of our assets because we're opening ourselves up to the same, all the liabilities of that person. So hopefully that's helpful. All right, number 2. Please elaborate on a final expense trust and how to set it up, or is it like a prepaid funeral contract or prepaid burial offered by a funeral home? So a final expense trust, it's a tool. It's not like a legal entity or anything like that. It's not like we set up a separate trust for you or anything like that, or you have to pay money to set up a trust. Really, what we're doing is we're taking money and we're moving that money over into, typically we use a company called NGL. And really what it is it's not an insurance contract per se, but they just pool the money into this kind of trust. And everyone kind of pools their money, different people pool their money into the trust. And then when someone passes away, whatever you've put in plus whatever growth gets paid out directly to a beneficiary within 24 to 48 hours upon death. All right. So you list a beneficiary, which typically would be your personal representative. And then now your beneficiary has funds to pay the funeral home. So why people go this route is that there's different ways to cover your final expenses. And I'm not just talking about your funeral, but all the other things that go along with it. Taking time off work, if people have to fly in, or your personal representative or trustee has to fly in or something like that. So, but funeral is the first piece of it. And a lot of people look at it as, well, I have money and of course it's going to be taken care of, or my kids have money. But really there's 3 ways that people typically look to cover final expenses. Because the issue is that when you pass away, someone has to pay for that funeral. And even if you've listed people as beneficiaries of your different accounts, they're not going to get access to it until, and this was actually brought up right here, until there's a death certificate, right? How do you get a death certificate? You get the death certificate from the funeral home. Okay. They're the ones that get it from the county. So typically to get a death certificate, it takes anywhere from 7 to 14 days. So the first way to pay for a funeral is have your beneficiaries pay for it, and then they're reimbursed from your assets or your estate or your trust. Okay. But the problem with this is that there's a 7 to 14 day period. And so in certain situations, probably not a big deal. If the beneficiaries are doing well, they don't necessarily need the money. they can pay it up front. Again, a final funeral or final expenses, kind of 10,000 is a rough guideline. Could be less, could be more. But if beneficiaries have the money liquid, they can just pay it, and then they can get reimbursed in 7 to 14 days from the estate. Second way we see this taken care of is adding kids' joints to things like checking and savings accounts. I'm not a big fan of this because by naming someone joint, you're opening yourself up to all the potential liabilities of those people. So if one of them were to get a divorce, lawsuit, creditor action, bankruptcy, then you could lose what's in that joint account. So joint ownership is great for a married couple, but I'm not a big fan of naming kids jointly or beneficiaries joint on any of your accounts. Because again, I want to make sure you're taken care of. If they run into an issue, you might lose that joint account. But that's the way that, because they have immediate access to it, they could just use your funds right away to pay for that final expense. And then third way would be through a final expense trust, where, like I said, you move, say, 10,000 into this, it grows at maybe 0.5% or percent a year, not great, but it's one of the advantages is, again, it pays out upon death within 24 to 48 hours. So you can pay for the funeral or whatever it is right away. And then also it's asset protected. So this is a big one. It's protected from any type of nursing home or Medicaid spend down or creditors lawsuits, just like our asset protection trust that we can set up. Okay. The downside is that you're locking your money up. You don't have access to it because it's really set aside to pay for the funeral. Also completely transferable, meaning that we can use it at any funeral home. And that brings up the fourth option, is prepaying at a funeral home. This works if you know for sure where you want to be cremated or buried, and there's no issues with that funeral home, they don't burn down, or etc. So that's also a good option as well. I have plenty of families that the whole family is buried at the same place, so that they know for sure that's where they're going to be. If that's the case, then that certainly makes sense. So hopefully that was helpful. All right, now a bunch of questions came in here. Let's see. What about filing my tax return for the year, especially if I owe taxes? This is getting up into this first question again. Yeah, that's where it gets a little bit messy. So worst case scenario, let's say you don't do any type of planning. So the question is, what about taxes? And again, getting into the situation where you have no will. Well, if there are issues that pop up after death, like filing taxes and that type of thing, that might be where now we have to start worrying about going to probate and getting appointed a personal representative. So long story short, rather than going down that rabbit hole, let's create that legal structure, that rule book, so we're not relying on the government's rule book. So let's appoint someone with a will as a personal representative. Let's appoint someone as a trustee, versus having to go to court, now go through a 5-month court process to open up a probate, have the court appoint next of kin as your personal representative. Much easier for everyone is just to have that rule book created. Regarding the first question, so credit card debt, it seems that credit card company can't get access to the money in the financial accounts that will go to beneficiaries. Basically correct. They can only come after the probate estate, and as long as the credit cards were not used to benefit anyone else other than the deceased, they can't really come after any beneficiaries. They could open up a probate estate, but as long as everything avoids probate, you should be okay. Now, so kind of taking it to extreme, you could run up a huge credit card bill and then pass away, and then the credit card company is going to be stuck on the hook for it. I'm not advocating that per se, but it is unsecured debt. And the worst thing they can do is ding your credit. But if you've passed away, chances are you're not going to be getting a lot of loans in the future. So, so hopefully that was helpful. All right, here's another question. If you're a beneficiary on an account, such as a traditional IRA or money market, so let's say we have a IRA, which is very different than, say, a money market, because one is a qualified account that doesn't have taxes that have been paid, versus the other one is a taxable account. All right, so if you're a beneficiary on an account such as a checking or traditional IRA that is a is taxable, do you always have to pay tax, or are you exempt from paying tax if the accounts fall under a certain limit? Does the beneficiary still have to tell the IRS about the inheritance if they're under the allowable limit? Okay, so really what we're talking about is, okay, let's say we have these two accounts. Now we have a death where now these accounts are going to a beneficiary. What tax consequences do we have? So the first thing we need to worry about is estate taxes. So this is just looking at the total value of your estate upon death. Would you owe any estate taxes? And right now, as long as you pass away with less than $11 million as an individual, you owe 0 estate taxes. So add up the value of your life insurance, your real estate, your business, your IRAs, your Roths, your money market, your checking. If all of that is less than $11 million, when you pass away, you don't owe any estate or death tax. Now, we know when the Tax Cuts and Jobs Act expires, that's going to down to $5 million adjusted for inflation. And that's supposed to happen either when President Biden changes it, or 2025. Now, potentially, this estate tax might drop down to $3.5 million. That was part of last I saw of President Biden's tax proposal. So if you do have an estate, add up everything, and it's greater than $3.5 million, there's some strategies right now that we should take advantage of prior to the estate tax exemption dropping. So that's something to take into account. If you do have a larger estate, there's certain things that you need to do, and we can help you with this prior to the estate tax exemption dropping to remove maybe some of the assets from your estate. So that's the first tax. So as long as you're below the limit, you owe 0 tax on those. Now, the second tax that we have to worry about is the income tax or the gains, okay, or the capital gains, and we'll talk about this. So IRAs, and again, if you remember our tax buckets, we have taxable, tax deferred, tax free, income tax free, and then tax free, we'll call this tax free plus. So it's income and estate tax free. So IRAs fall into this tax deferred account. Okay. Checking, savings, money market, brokerage are typically on the taxable account. Okay. Tax deferred is always taxed. Whenever you pull money out, it's going to be taxed. Taxable account is maybe taxed. And so here you'd only be taxed potentially on the gains, okay, on the growth. So if you had 100,000, it grows up to 110, you might be taxed on the 110. So with the IRA, your beneficiary, this is pre-tax, meaning you have not paid any tax on this, okay? And then we also, just continuing the conversation, we have like Roths, cash value life insurance over here. And then here we have life insurance, irrevocable life insurance trusts. So IRAs are pre-tax. So if we have, let's say, 300,000 inside of an IRA and you pass away, you don't really have 300,000. You still have income tax liability. So there's still tax liability. And your children will have to pay, or the beneficiaries will have to pay the tax liability. So let's say you have 300,000. I can't do math in my head, but let's say 20%. So there might be a $60,000 tax that would have to be paid within 10 years due to the Secure Act. So at the end of the day, your beneficiaries are walking away with 240,000 because the tax has to be paid. Now, the interesting thing is taxes, most people think taxes are going up in the future. So that's why with a lot of our clients, we're talking about strategies of moving money out of these IRAs to either tax-free or even tax-free plus if we're concerned about estate taxes. Because if taxes go up, the value of your pre-tax accounts go down, because anything you pull out of that IRA is going to be taxed at marginal income tax rates, which are scheduled to go up and which a lot of people think will go up. So that's the income tax. Now, on the money markets or on any taxable accounts, let's say you have $100,000 here, whether it's a money market or brokerage, and let's say upon death, it's grown to 110,000 upon death, and then let's say the kids sell it, and again, I'm just kind of making up numbers, for 200,000. So this is one of the proposed Biden changes, which someone asked, do you think any of these changes will be retroactive? Probably not. Typically, they don't go, a lot of times they don't make changes mid-tax season. So if they do make some tax changes, chances are it's going to be for the following year versus for 2021. So if some of these proposals were to go through, it's going to be most likely in 2022. That's why I'm saying that there's some strategies, especially on the estate tax world, that we would want to take advantage of now while we're still within the old rules. And so this is one of those things that, this is one of the things that may change. The way we have it now, so right now on any taxable accounts, you get what's called step up in basis. And the way step up in basis works is if you purchased it for 100 and now it's grown to 110 at date of death. So this is the date of death. And then the kids sell it for say 200. What is the basis? What are the gains? Is it 100,000? Because we're going from 100 to 200? No, we get a step up in basis where let's say actually it was 150. So instead of paying having gains of potentially $100,000, the kids or beneficiaries would only have to pay the gains from date of death to when they sell it, which might be 50,000. So this is what I call a stealth tax. Like a lot of people don't understand step up in basis, but right now we get a benefit. Like if you have, I met with some clients the other day, they purchased some individual stocks that have a very low basis. If they were to pass away, the kids get the step up in basis where they're not going to have to pay any of those gains. But what the President Biden's proposal says is that we're getting rid of the step up in basis. So now in that same situation, the kids or beneficiaries would have to pay the full amount of the gains. So if it grew from 100 to 200, now the kids would have to be responsible on $100,000 worth of capital gains, which now maybe would be taxed. So we know this bucket, the taxes are going up, and we know for sure you have to pay the tax on it. So if taxes are going up, let's look at strategies to move the money out of those accounts. Here, we still have step up in basis, but that could be going away under Biden's proposal. So that just puts more of an emphasis on getting money over to the tax-free or the tax-free plus bucket. I am maybe 50-50 on whether they truly will get that step up in basis passed, maybe even less than 50-50. I think that's just kind of a bargaining chip. I was listening to a podcast of one of the experts in area of tax and legislation, and his feeling is that some of this Biden proposal and some of the tax proposals we see are bargaining chips where, okay, it's going to be, he wants to get everything, but he's going to scale it back to get a consensus to actually get something through. So I don't think everything that we're hearing right now will be in any final tax bills. So we're not spending a ton of time on, we want to understand what's going on now with an eye of what may happen. And there's certain things that we think will happen, like the estate tax exemption dropping. That's already part of the current tax law. Whether step up in basis becomes an issue or not, That's something that we can plan for when it happens. Something we can't plan for in the future is when the estate taxes drop. So again, this one, there's a window of opportunity. Likewise, moving money from IRA to Roth or to ILETs, there's a window of opportunity from now until whenever the Tax Cuts and Jobs Act expires, which is scheduled for 2025, but could be even sooner. So yes, that was the tax conversation. Other questions that came in. How long should it take to see a response from the IRS regarding your tax return if you sent them in via mail, signed on to IRS and got a response that they couldn't find me? What should I do? That is more of an execution question that I'd have to ask our CPA. One thing I do know is, well, two things. One is mail is slower than molasses, it seems like. I received a Christmas card in February from someone who lived about a couple miles down the road. So that could be the first issue. The second issue is we know the IRS is overwhelmed, as well as a lot of CPAs because of all the tax changes we've had. And then also, as part of one of Biden's proposals, he has another $80 billion allocated to funding the Internal Revenue Service. So along with the $1.9 trillion pandemic relief, the $2.3 trillion infrastructure bill, we also have an $80 billion proposal to go to the IRS. So that question I don't have an answer to. All right, what is the best way to put money away for grandchildren to use later as an adult? I'm not interested in a 529 as money could be used for something else. So the best way, it's really going to depend. But the big thing for me is taxes going up in the future. So if I can save for a beneficiary in this tax-free bucket for a child in a tax-free bucket, then that's the route I want to go. And really in this tax-free bucket, if you're looking for tax-free growth, you only have four options when it comes down to it. One would be Roth IRAs. So if the kids are working and they don't have an income issue, you could gift $6,000 to them, which is under the gift tax exclusion. And then they could move that money into a Roth as long as they have income and they meet certain requirements. So gifting money that then puts it into a Roth is one option. So all of these are tax-free. IULs, Index Universal Life Insurance, not that we're looking for a death benefit, but due to, what's the code section? 7702, just like you have a 401k, that refers to a code section. Insurance, if it's set up properly, also grows tax-free. So you could set up tax-free growth vehicles through insurance that the cash value could grow tax-free for them. 529s, like you mentioned, have to be used for education, though. The other tax-free vehicle is health savings account, but it's not like you would open up a health savings account. So those would be three tax-free options. You could have them open a Roth IRA that you could then gift money to that they could then contribute. We're doing that with some of our clients, as well as you could look at a cash value life insurance policy that's maybe in their name that grows tax-free for their life. Also, if you do have an estate tax issue, one of the things that we're doing is we're setting up trusts. You could gift to a trust that then could be used for the benefit of the beneficiary. And then it's just deciding how you want to invest inside of the trust. It could be, you could invest in the market, like a brokerage account. We use TD Ameritrade. So you have different options, but I would first look at something that's tax-free. All right, let me see. What other questions do we have? So I answered that one. Another one came in over here. More follow-up questions. What if a beneficiary is the spouse? Upon death, can the beneficiary choose to roll over a traditional IRA or money market into something else to avoid gains, growth, or shift into a Roth so not to pay tax again in the future? Yeah, so we have different rules when you pass away for death, whether it's going to a spouse versus a non-spouse. So for example, with traditional IRAs, when one spouse, we almost always name the spouse as a primary beneficiary. When one spouse passes away, that IRA can then become, we can do a spousal rollover where now that becomes the surviving spouse's IRA. And maybe they don't have to take out required minimum distributions until they turn 72. So the question is, or my comment is that the rules are going to be different between a spouse versus a non-spouse with a lot of these things. What is the best? Put 529, answer that. Final expense trust. What is the proof of death required by NGL? It's actually a funeral home signing off on it. So that's the proof of death. So you just get a signature and you're good to go. How old can a person be and still get a large life insurance policy? Answer is, it kind of depends, but with insurance, so let's say we wanted to set up an index universal life policy. And think of these as kind of a pie that we can, depending on what our goals are, we can change the size of these different pies. So maybe we want tax-free income. Okay, then we would structure the policy one way. Maybe we want a death benefit. Most people aren't super excited about that, but sometimes leaving a legacy is important. But the nice thing is that death benefit can double as a long-term care benefit. So we get tax-free income, we can get a death benefit, and we can get long-term care benefits. And we can just kind of cut up the pie however we want with those stated goals. Plus, nice thing is it's protected against market volatility. So it's going to grow like this versus you have money in a market, kind of grows like that. So it creates some diversification. But with a policy, there's a couple roles. There's the role of the owner. There's the role of the insured. And then there's the role of the beneficiary. And so we can change this around. The role of the insured, that is where age and health plays a role. Okay. If we're getting kind of 75 plus, then it's going to be a little iffy to be able to do this, just depending on health. If we have a super healthy 75-year-old, it still may make sense. But a lot of times as we age, we start to collect some of these pre-existing conditions. But that only applies to the role of the owner or of the insured. The role of the owner, you could be 80 plus. You could have a trust as the owner. It really doesn't matter. So age doesn't matter in terms of who the owner is. And then beneficiary can be whoever you want. It could be a child, a kid, could be a spouse, could be a trust. So let's say you wanted tax-free income or you wanted a death benefit to go somewhere. Well, more focusing on tax-free income. We could have like one of your kids as the beneficiary or the insured, and you could be the owner, or we could have a trust as the owner. So how old can a person be and still get a large policy? If you're talking about being the insured on the policy, it's really based on age and health. Plus 75, it's going to be kind of iffy. And that's why we have a 2-page health, long-term care, and life insurance questionnaire we send prior to typically looking at this so that we can get an idea before we go through and submit an application or anything like that. All right. If you do have questions, please get them in. This is the last question I have that someone submitted. If a spouse is listed as a beneficiary, then I assume that it is the best way for her to receive the funds tax-free. If the spouse also has a trust, should the spouse wait until funds are received before transferring them into his or her own trust? So let's say we have a married couple. So let's say we have a husband and we have a wife. And I'm a much better attorney and advisor than artist, so bear with me. All right, so let's say the question is, if a spouse is listed as a beneficiary, then I assume it is best for her to receive, or him or her to receive the funds tax-free. If the spouse also has a trust, should the spouse wait until the funds are received before transferring into the trust? So let's say we have maybe separate trusts, and one spouse passes away. Should the assets go directly to the spouse, or should they go to the trust? I guess the answer is it depends. Let's say it's IRA money. It really depends. It depends on what your goals are. So I would say typically when we're setting up a IRA account, so let's say husband is the owner of the IRA, a primary beneficiary typically is going to be the spouse. Okay. Contingent beneficiary typically would be the trust, and this would allow for a spousal rollover. So from a tax perspective, it's kind of the simplest thing. And then let's say the husband passes away. Now the IRA goes to the spouse. Now she would be now the owner, and typically we would have her primary beneficiary now be the trust. So that's typically how we would do it, but there are certain situations and reasons why we wouldn't want to do that. Those are more of exceptions than anything else. Maybe if it's second marriages, maybe kids from a previous marriage, maybe concerns about the spouse remarrying, things like that. So I would say as a general rule, and again, all of this is general advice. Your situation may have some facts that would determine that or point us in the direction that we'd go in a different way. But yeah, primary, typically we have spouse as primary beneficiary of qualified accounts. This is a key distinction, qualified accounts. So qualified accounts have a tax qualification. So typically we're talking about IRAs, Roths, 401ks, okay? Non-qualified, typically we name the trust as the primary beneficiary. And the main reason is there's a tax qualification with these, right? Things like life insurance, typically we would have it go directly to the trust. The trust would be the primary beneficiary. The trust would even be the owner, depending on it. Thank you very much. You're always so helpful. Thank you. I appreciate that feedback. Specialist beneficiary. Okay, I answered that one. All right, is it better to pay off our house with our 401k so we don't carry our mortgage into retirement, or let it stay? Are there tax benefits for either option to take into consideration? Unfortunately, this is going to be a depends question, but let's talk about it. So we have a house, and let's say it's valued at $500,000, okay? And let's say we have a mortgage of $200,000, all right? And let's say we have a 401k, right? And we probably have other assets. Let's say we have $1 million in our 401k, all right? So the question is, should we pay our house off with our 401k so we don't carry a mortgage into retirement, or let it stay? So there's really two schools of thought. And ironically, this was my undergrad. I majored in finance and had a degree in psychology. So there's a numbers answer, and then there's a feel-good answer. The feel-good answer is being debt-free. You know, that's like people's American dream, is that old paradigm of I retire, I get my pension, pay off the house, I'm good to go. And there's a lot of value in that. I'll tell you from a number standpoint, depending on your situation, everyone's situation is a little bit different. It really depends on one factor. What is your interest rate? That's probably the number one factor. And there's a general rule that if your interest rate is less than 4%, which if you have a mortgage out there right now, a lot of people are refinancing. And we've had a lot of success helping people with that. So if you're considering refinancing, reach out to us. We can get you in touch with someone who's having a lot of success right now, getting very low rates. But if your mortgage rate is less than 4%, then you just kind of look to the market, and if we can get 5 to 6% rate of return on the market on investing your assets, right? So if we're growing 5 to 6% here, kind of think of this like a bucket, right? So you want to be debt free, and that makes sense. And you're leaking out, say, I have people at 2.5%, right? So that's coming out of your bucket, right? And we don't like losing money. And the thought is you plug the holes, right? Someone writes in 3.3%. So perfect. So this is 3.3%. And again, I'm not making any guarantees, and I can't guarantee anything, but if we're making 5% in the market, that's 5% more that's coming into your bucket, right? And so you have two things working for you. One is the arbitrage, right? So the difference between 5 and 3.3, I can't do math in my head on the fly, but you're getting 1.7% rate of return on that deal, right? So your bucket is filling up farther than it's going out. The other thing is this interest, you're the one that's getting compounding interest, right? Like you're getting compounding interest versus letting the bank get compounding interest. So a lot of times, just from a number standpoint, it might not make sense to pay off that house. But these are both good. I'm not saying one is wrong, one's right. And there might be other reasons to pay off the house, maybe. But from a number standpoint, really the most important thing is looking at that arbitrage of, okay, what is the difference? What can we get a rate of return versus what is our mortgage rate? But even if the numbers say otherwise, I'm not discounting that peace of mind that you have of having paid off the house. Because at the end of the day, that's really what matters. It's peace of mind, being happy in retirement, right? And if that's going to be something that's holding, kind of stuck around your neck is the debt, then I would say pay it off. So again, the answer is it depends, but I would just suggest look at it from a numbers perspective, and then also look at it from a psychological perspective, to figure out what is the best answer for your situation. So, all right. That is all the questions I have. I appreciate, let me stop sharing. So let me make sure I have everything over here. Thank you so much. You are welcome. I think I answered all the questions over here. All right. So with that, I want to thank everyone for attending. Had a really good turnout. I appreciate all 30 plus people. Alan, Barry, Brian, Carolyn, Daniel, Danny, Don, Dottie, Ed, everyone else, Nikhil, Joe, Kathleen, Laura, Ray. Thank you so much. Make it a great week. If you have any questions, feel free to just reach out to us. We're here for you. Take care. Have a great week. Thank you. Thank you. All right. Take care.